Dylan, I have a question. I think some of us are supposed to go to Probes today. How do we know when to go?
Dana from Appropriations is going to send your wanika.fisher@house email address an email letting you know that the bill is next up. And there will be a Zoom link in there with it for you to pop over to that hearing. So Chairman Clippinger, you're ready to go.
Thank you very much. Good afternoon. This is Wednesday, the 20th of January, 2021. Welcome to the House Judiciary Committee for our hearings today of 4 bills. Members, remember to set yourself to mute. Only unmute when I recognize you to ask a question. And witnesses, you'll be able to unmute yourselves when I recognize you to present your testimony as well. We're going to have 4 bills today. All of them are going to fall under the 3-minute, 2-minute rule. So 3 minutes for the sponsor, 2 minutes for the witnesses. We'll go in order of House Bill 213, 305, 260, and 227. So the first one is House Bill 213, and that is Delegate Cardin. I don't believe there are witnesses apart. Correct. It's just Delegate Cardin who's going to be speaking on the bill. There are a couple people who are signed up just to answer any questions that people have. They're not, they're sort of testifying, I guess. So Delegate Cardin will go with you for 3 minutes, please.
Thank you very much, Mr. Chairman. And thank you all for listening to this bill. As you've heard this bill before, I did not introduce it last year, but it was introduced in the past. This bill basically, what I would encourage everybody to do is just to read the very short fiscal note. But basically what this bill does is it prohibits parties from requiring indemnity against liability for that party, which is, as the fiscal note specifically says, is against the, this bill is to codify what is against the public interest and what has been deemed to be inappropriate anyway. In fact, and I'm just trying to pull up the specific language in the fiscal note. In common law, a contract is deemed to be unenforceable if it has an illegal purpose or is contrary to public policy. The prohibition applies to architectural, engineering, inspecting, and surveying services. So these are really for architects and engineers who are required by certain contracts created by the state to have to indemnify the state for wrongdoing by the state or other actors. So they are required to pay the legal fees for the wrongdoers by the contract, even if they weren't actually the wrongdoers themselves. And what this bill does is it prohibits the state from doing such things. If you'll read, I just want to pull up the specific sentence here. In the second page, very beginning of the second page, the bill prohibits any clause requiring a design professional to defend a promisee or other party against liability for claims for damages or expenses, including attorney's fees, alleged to be caused by the professional negligence of the derivative parties. This type of clause is void and unenforceable and it's against public policy. So those types of clauses is what we're trying to prohibit because they are unenforceable and against public policy. The only entity that has given any opposition to this is the Attorney General's office. If you read the Attorney General's letter and then you read this fiscal note, the fiscal note refutes everything that the AG suggests is the reason why it should be the case. So the point is that I think the AG doesn't want it because they want to be able to have the flexibility to be able to do these kinds of contracts, even though they are considered unenforceable and against public policy. That being said, I'm certainly happy to answer questions, and I'm also happy to have other folks who are really familiar with this, be able to chime in if I don't understand. And I'm also going to provide you a letter, which I tried to email just now, but for some reason didn't go through. I will email it by the end of this hearing today, of refuting everything that the AG said in his letter.
All right. Thank you, Delegate. There is a question. There are 3 people who the delegate has asked to be able to assist in answering questions: Tony Fascarella, JB Osborne, and Michael Ruber. So we will let them, or Raber, I should say, we will let them in. They are in. And we'll begin with Delegate Atterbury for starters. Delegate Atterbury, then Williams, then Griffith.
Thank you, Mr. Chair, and thank you, Delegate Cardin, for bringing this bill. I do think we've seen this bill past 2 sessions, perhaps. I don't remember if we passed this bill last session, but question for you or any of the other folks who have joined us to answer questions. Is it fair to say that these types of indemnity agreements have a disproportionate effect on smaller businesses, and particularly minority and women-owned businesses who don't have access to the capital or the funds necessary to defend themselves against something that isn't necessarily their fault? So essentially, they could be paying, hundreds of thousands of dollars, if not more, which could in fact actually put the smaller businesses out of business. And they ultimately could be found not to be at fault. So in addition to being against public policy, is that a fair statement?
Yes, thank you very much. And I'll just add to that you'll note that there's a letter in with your testimony from minority and small businesses and women-owned businesses, specifically saying that these types of clauses are very detrimental to their ability to succeed. And we in the state of Maryland are trying our best to get contracts for these types of businesses with the state, and this just impedes that. If there's anything that the council wants to add, I'd be happy to let them follow up.
All right, we will go now. It's going to be Delegates Williams, Griffith, Malone, and McComas. Delegate Williams.
Yes. So Delegate Cardin, you mentioned that this would, so the way I'm reading it, this would apply to contracts all across the board, not just necessarily contracts entered into with the state of Maryland. Am I reading this correctly?
Yes.
Okay.
However, it's really the contracts with the state that where this is, I mean,
right, but
most of these contracts are happening with the state, but yes.
Well, okay. I mean, there are these types of contracts that happen with the state, but wouldn't it be fair to say that these contracts also occur in just the private sector in general, between developers and builders and architects and design firms, or, just in general real estate construction type of endeavors in the private sector?
I'm going to refer that to Tony if you want to follow up on that question.
Thank you, Delegate Williams. Yes, it does apply in the private sector also. What we kind of see this bill is basically the purpose is that we determine who is at fault with whatever the claim is before we assign a duty to defend and payment to pay for legal fees for an owner, whether it be public owner, the state, or private owner. I know JB might be able to provide a couple additional comments on that too, if that's okay.
Sure.
Sure. I'm happy to chime in. I think your point is valid, Delegate, that the way the bill is written, it applies generally to any contract for which the contract would try to hold through an indemnity provision the architect or the engineer or the design professional responsible to indemnify or defend claims for which it's not the cause of. So the idea that whether it's a state contract, whether it's a local municipal contract, or it's a private contract between a general contractor and a designer, or a private owner and a designer. The public policy argument is that it shouldn't be, it's against public policy to hold a party responsible, in this case, a design professional, responsible for damages for which it did not cause on the first hand, and secondly, to defend against claims which allege potential defects or allege injuries or damages, but which have not yet been established to have been caused by the design professional.
Okay, right. Right. No, I get that. So I guess my question is then why can't, if in a private, in a private party setting where you have just two companies contracting with one another, shouldn't that just simply be part of the contractual negotiations between the parties before they simply enter into the contract? That's something that they can agree either to not include in their contract or to modify in their contract. I'm just trying to figure out why we need to enact this statutorily when the parties have the right to negotiate the contracts amongst themselves. I get the state might be a little bit of a different animal, but with regards to just private companies, I'm just not understanding why statutorily we need to dictate what they can and cannot agree to in their private contracts.
Right. Yeah, that's a very valid and fair point, right? Is it the legislature's job to negotiate contracts or to dictate the terms of contract between two contracting parties? The biggest issue is that the majority of contracting in engineering, particularly, but architectural, comes from public sector projects, big infrastructure projects, just as an example, roadways, bridges, tunnels. And so typically it is the procurement agency who issues that project. And then underneath that contract, there tends to be a myriad of contracts for other design professionals. So to use the small business impact, right? We may hold a contract as a prime consultant with government, but then we have 10 or 12 contracts with subcontracting firms that sure, there's a certain level of equal footing or bargaining power, but typically the prime contractor is going to flow down all of the same obligations with respect to indemnity and defense. So if you're able to say that in a public contracting perspective, it's unenforceable, then you shouldn't be able to sign a contract that doesn't include this provision, but then require something more or beyond, require your subcontractors to indemnify you as the prime for something that is beyond the risk that you have upstream. But without the sort of public policy and prohibition on it, you will have somewhat of a free-for-all in terms of who has equal bargaining power. The other thing I would add is that unlike many professional services, legal services, accounting services, services of medical doctors and physicians, typically design services, engineering and architectural services are procured through competitive procurements, right? So it's
right, but that's right. But again, that's once again dealing with government projects. My concern is more so with just a regular consumer, say, a regular consumer who is wanting to say build a house. They're going to hire a design expert to design the plans for that particular project. They're not a governmental entity. And so by enacting this legislation, that's also going to affect just general consumers out in the general market as well.
Yeah, I think you're right. There will be, but from a public policy perspective, if you hire an architect to design your house and they spec floors and somebody installs those floors and somebody slips and falls on that floor, is it the architect's fault, or does the owner, whoever that may be, whether it's the public or
that's for a court of law to figure out.
That's right. And so what our bill does is it says, once a court of law has established who's responsible for this, if the fault of the architect or the engineer is the proximate cause of the loss, then absolutely these indemnification provisions and the defense obligation should be enforceable, but not until the court has actually apportioned liability or determined who actually is the proximate cause. And so the bill, if you read the bill, it's tied to proximate cause as opposed to the onset of the allegation and the onset of the claim.
Mm-hmm.
I've got something to add on this as well. My name is Michael Harbour, Mr. Chairman, members of the committee. Delegate Williams, you were asking about why this should be a factor in private party contracts. And I think an important factor here to keep in mind, I'm an insurance agent and I specialize in architect and engineers business, and I've been doing this for the last 20 years. I submitted some written information through Delegate Cardin as well, which kind of outlines some of the coverage issues in detail. But I think that it's helpful for me to point out here that these exposures that we're trying to get in this bill, trying to bar as public policy, are not insurable under the insurance policies of the architects and engineers. So if you compare that to contractors and other types of vendors, these exposures are insurable under a contractor's policy. So a general contractor can have his general liability insurance company add the indemnity as an additional insured under that general liability policy. So they've got coverage for that. But with architects and engineers, the insurance companies will not do that under the general liability or the professional liability policy. So small firms in particular, are going to be left needing to face the risk of having to pay for that entire claim themselves if they sign a contract with those uninsurable provisions. So that's another reason that I think it's important to keep this in mind for private practice in addition to public.
Okay, I mean, I did see some of that. I mean, what I read gave me the sense that there are very few insurance companies out there that will insure on those claims, which I guess that's for the insurance market to deal with. But my concern is just general consumer protections for just general consumers out in the marketplace. So,
well, I think if anything, it would raise costs for the consumers to have these additional risks faced by the design firms, because they would then have to, theoretically pad their fees to take into account the additional risk of having the uninsured exposures that they would have to pay for themselves if things were to go wrong.
Mm-hmm.
And it's not that this has been a universal coverage point in the insurance market for the past 40 years. In recent years, there has been one insurance company that has started offering coverage, but I've got to stress that this is very much an unproven coverage. The last time I spoke to the underwriters from that company, they hadn't had any claims for it. And they had a very limited number of policyholders. So it's a very unproven type of coverage, and it's something that's called claims-made insurance, which means that the insurance company can walk away at any time. So you could sign a contract tomorrow, even if you had bought that policy. In a year, the insurance company could say, "We're no longer going to offer this coverage to you. We're walking away," and then the design firm still has that exposure until the statute of limitations is run. So it's not that there are a few companies that will offer it. It's no insurance company that offers professional liability or general liability policy will add that coverage to their policy. There's one company that I know of that will do it, and like I said, we've got some big questions about them in the insurance market.
Okay.
Thank you.
Very much. We'll go now to Delegate Griffith, then Malone and McComas.
Thank you, Mr. Chairman, and thanks for putting forth this bill. A couple of questions as one of the non-attorneys in the committee. You mentioned a term called proximate cause. Could you explain that to me a little bit, please?
Would you like me to do that, or would you like to do that, JB?
Delegate, I'll defer to you. I'm happy to do it. I think I was the one who brought the word up to begin with, but Delegate, if you want to speak to it,
Go ahead. I'll follow up with Delegate Griffith. I need to.
Sure. So proximate cause is sort of a legal term that is thrown around by lawyers. So I appreciate the question. What it is it's to distinguish every direct cause or every actual cause in fact from those causes for which a court of law would find legally sufficient to result in liability. So one of the elements of a negligence claim is you have to have a duty. You have to in fact owe a duty to the party. You have to breach that duty, and then the breach of that duty has to be determined to be what they call the proximate cause of the loss or the proximate cause of the injury. And that's because in many cases it's hard to discern against, is it the car salesman who sold you the car's fault that when you pulled out of the lot, you wrecked the car? Had he never sold you the vehicle, you never would have been involved in the car accident. the car salesman who sold you the car, unless it was a defective vehicle, is likely not legally the cause or the proximate cause of the vehicle accident. But for the fact that he ever sold you the car, he wouldn't necessarily be responsible. So in the context of this bill, it's making sure that the mere fact that the engineer designed the bridge and the bridge happened to fall down, it doesn't necessarily establish that it's the engineer's fault yet. Now, if it turns out that in the proceedings, a design defect, the engineer breached its duty of care by under designing the bridge, and the design deficiency is the reason that it fell down, then clearly the proximate cause of the injuries would be tied to the engineer's negligence. So what we're trying to do is divide between all of the parties who happen to have a fingerprint or sign a piece of paper related to the project, and only have it be those liabilities for which the engineer or the architect is legally responsible.
And another question, has this been rolled out in any other states?
Yeah, I think there's a handful of states who are currently considering the bill or just in recent years have passed similar iterations of the bill. The bill that's before you was actually modeled after a bill that recently passed, I think in the North Carolina legislature a couple of years ago. I believe Ohio has a bill that's pending currently, just passed, I think, the House this year. And there's probably a dozen or so states who have rolled it out just recently. I don't have a survey of how many states that is, but I think we could certainly provide some updates on that.
And just my last question, in the states that's rolled it out, what has been the effect? Has it had any positive impact, any impact at all?
Yeah, I mean, I would certainly on the industry, from an industry perspective, I think it has a positive impact on engineers and architects' risk appetite and willingness to go after projects. So if you talk about the hard to quantify benefits, in addition to the small business effect, the hard thing to quantify is, are you getting firms who are more qualified or very well qualified to be interested in doing business in those states, rather than the reverse effect, which would be having to bear this uninsurable risk and just getting out of that business or not doing business in a particular jurisdiction because of the onerous contracting.
Thank you, I appreciate it.
All right, thank you very much. We'll go now to Delegate Malone, please.
I have a couple questions. The first being, what happens for a design professional group, an architect or engineer, who doesn't accept a contract with these provisions?
I'll try to respond to that, Delegate. Well, basically, we see these clauses quite a bit, and our decision is to try to negotiate the clauses out, and often owners won't. And then it's our decision whether we accept it and accept the risk, or we walk away from the contracts because of it. But the problem is that, our business is to do this work. And, it's kind of difficult to walk away from contracts that basically is your livelihood. And so you're taking on quite a bit of risk just to continue doing what you're doing and accept these duty to defend clauses.
So it's sort of pay or no play.
Exactly.
And then this question has somewhat been answered, but it's what's the current what was the original thinking for the requirement for these contracts? I mean, just explain that out just a little bit more so I fully understand it.
JB?
I can probably address that. I think the concept of indemnity and risk shifting provisions are very common, I think, as Mike had alluded to, in construction contracts, particularly with general contractors. So the idea that an owner is hiring a general contractor to build the project, and they want to transfer all of the risk to the project to the contractor that they're hiring to do it. So, whether that be a DOT hiring a contractor to go out and repair a roadway, all of the risk for anything that could go wrong on that site during the pendency of the construction is typically transferred to the contractor, and that is something that the contractors can insure. And so if it's a private development project, the same thing, right? The risk of loss on the site and the risk of injuries on the site is typically transferred to the contractor. So, if you go back to the inception of an indemnity provision, they sort of started, I think, in the construction world. And what has happened is over the years, contracts for construction related services, design, engineering, fabrication, those types of things, have borrowed that language. And so what we have in professional services agreements for engineers and architects has roots in the original contracting world of general contractors, but the distinctions that brought up from an insurance perspective make these provisions uninsurable and really onerous for design professionals, where they're pretty run of the mill for construction contracts.
Thank you.
All right, go to Delegate McComas, please.
Thank you, Mr. Chair. I just wanted to know, okay, by common law, these are against public policy. Have the courts, are you aware of any cases where the courts tried to enforce them? I realize that you want to nip it in the bud and not have the person, try to get something or worry about they're going to be sued and lose their business. I get that. But I'm just kind of curious. It's better if it's in a statute because it makes it very clear. This is how it should be. But I just kind of was curious, kind of the history of it's against public policy. Everybody can still throw it in the contract.
I'm sorry to interrupt there, Delegate.
No, that's okay.
The point is well taken. What this bill really does is try to codify the legislative intent that these provisions be determined to be against public policy, so that a court, when ruling it, can hold a contract provision that would include that unenforced, could choose not to enforce it. The current status is that the courts are not going to make policy decisions so much. The courts are gonna interpret the legislative intent, or the courts are gonna interpret the law and then render decisions accordingly. And so what we wanna do is to make sure that, if it's illegal because it's already written into a statute that says it's against the law, or if it's in a statute that says it's against public policy, then the courts are not going to interfere necessarily with that legislative intent. So the idea here is to say, this is a matter of fairness. We believe that public policy should put contracting parties on roughly equal bargaining power. And in many instances, you don't have that bargaining power because of the role. And so therefore, from just a fairness perspective, to hold one party responsible for all of the risk associated with a project simply because they designed that project just seems to be against public policy. And so for a court to only enforce an indemnification provision to the extent that the design professional is determined to actually be at fault and to be the proximate cause of the loss. So this would just help the courts to be more consistent with their decisions. There have been cases where courts have upheld the duty to defend a claim at the onset of a claim and upheld that as a contractual agreement, right? The courts don't want to renegotiate your contract. So they've enforced these provisions against design professionals to pay for legal fees and defense costs for claims which those same design professionals were actually found not to be responsible for. So it's great. You win the case, you find out that I wasn't responsible, but you're still held responsible, not only to pay your own attorney who defended you in the case, but to pay your client's attorney or to pay others involved with the project's attorney's fees because simply you signed a contract that said that you would.
Okay, thank you very much.
Sure.
All right. I think coming back for a second bite at the apple is Delegate Williams.
I guess my only other question I have, you mentioned a lot of times this goes on in the procurement process. Usually the general contractor will have this provision that they are now placing down onto the design firm, but then isn't the design firm having subs under them, which in turn, couldn't they just contract that responsibility down onto the subs that they're working with?
Sure.
I'm not understanding this process correctly.
Delegate, I think you're right. The fact is that they do. So if
Okay.
I happen to work for a mid-size or larger engineering firm, and I review contracts, all day as legal counsel for the firm. But our role in many cases is often as a prime design or a lead design firm. And so when we have an onerous provision in our agreement, we're certainly taking that requirement and flowing it down to the rest of the team. And so when you talk about unequal bargaining power, if we're working for a state or municipal client, we've already had to competitively bid the project. We then take those same contract terms and we would require all of our DBE, MBE, WBE firms to participate in that project, to accept the same level of risk as it relates to their work. Certainly if we have a geotechnical engineer, they're not responsible for mechanical design, but they would be responsible for that. But if we have an obligation to indemnify and to defend, then we're gonna throw that or flow that down to them. And so it does have sort of a disparate impact on some of the small and minority businesses who on the one hand we are required to meet certain participation goals, and we want to give ample opportunity. But then some of those terms, the difference between a large firm and a small firm, one claim being held responsible to pay millions of dollars in defense costs for a claim that you didn't cause, could be the difference of staying in business and going out of business.
Right. No, I get that. I guess I'm just looking at also the shared risk, because you are flowing that down to your subcontractors. So now you're sharing the risk, not just with you by yourself, but also with your subcontractors as well, by including that clause in their contracts.
Yeah, that's absolutely right. And ordinarily in 90% of claims, what's going to happen at the onset of the claim, depending on what the allegations are, is everybody's going to give it to their insurance carrier, and the insurance adjusters are going to look at it and they're going to say, who should really be leading the defense of this claim? Who really should? And
no insurance company wants to take it. They're going to try to pass the buck off to the other insurance company. I get that.
Right. And so what then happens in the design professional case is they will still look to the contract, and the professional liability insurance carrier will say, sorry, we have an exclusion for this coverage. And then the owner or the contractor may cite the contract provision and say, yeah, but designer, this, you designed the bridge, therefore you have to defend us all until it's determined that we're at fault. And we're saying, well, you're the one who got sued. Why do we pay attorney's fees prior to a finding of liability, not related to our own defense, but related to the defense of others?
Right. And then just other follow-up question, in just your experience, and with your firm, you mentioned you're a mid-sized firm, how many times has this occurred for you guys, just where you've had to pick up the tab because of this type of lawsuit? Out of the percentage of your contracts, would you say 50% of the time, 35% of the time?
So fortunately, in the experience of our firm, we don't have a lot of claims because we try to avoid the claims up front. But I will tell you that probably more than 50% of the contracts that we are signed, even after the opportunity to negotiate those contracts, still require this duty to defend. And most of those scenarios where we can't negotiate it out, it's because the owner's contract, whether that's a private owner or a public owner, the owner's contract includes it. So when you talk about the ripple effect, if we're playing a role as a subcontractor, we have very little, if any, chance of negotiating out a duty to defend when our client who's working for the owner has that same obligation. And so we see it in the majority of our contracts. Fortunately, we don't have the claims experience, at least personally, individually at my firm's level, to have been faced with this. But again, this is one of those sort of proactive requests that the industry, ACEC and others in our industry are looking for, because nobody wants to be that scapegoat, or nobody wants to be that business
to be the first one.
That one claim where somebody enforced their contract.
Okay.
I will add that it has pinched some local Maryland firms, though, with other state agencies where they had to pay the defense costs for a state agency for something that was determined that they were not at fault at, ultimately after years in the courts and everything. And in this one example, it cost the firm $500,000 that was not retrievable.
Got it, but that was with a state contract. That wasn't a private contract.
It was with a state agency, yes.
Okay. All right. Thank you.
Delegate Moon.
Thank you, Mr. Chair. Sorry, I'm stepping out of my usual terrain here, but this conversation is bringing me back to a few law school basics. And I guess, well, as we're asked to impede contracts, and I've actually am cooking up a bill myself on a different topic and had to revisit this whole area. I'm curious just about where, and this might be a question for the sponsor and potentially the chair, but where we would place the line on whether impeding a contract is something to interpretation and when it becomes a matter of codifying our public policy interpretation. So the only reason I bring this up is I was reminded that, in Maryland, we have a codified uniform commercial code, UCC section, dealing with unconscionable contract terms and clauses. And I would just look there and then think like, well, surely someone could see their way to finding certain things unconscionable during COVID, or if it's just highly inequitable situation as you're describing could happen. We recently, thanks to the Catholic Church, discovered that there's such a thing as uncodified language that guides interpretation of statutory provisions. And so I guess I'm just curious, since the UCC has to be uniform, when something makes it into an annotation or uncodified language versus into the code itself when we are talking about interpretation here. So it's just a few concepts to think about for whether the code is the proper avenue, and whether anyone has looked at some of these other possibilities.
Yeah, that's great points, and certainly we should sit down and talk about that. But I would say that in this case, we have, we clearly have language in both in the code and in the fiscal note specifying that this type of contract is considered to be against public policy, this type of action. And we also have testimony saying that this is inhibiting the ability. We have one example of a $500,000 cost to a company. That company could afford it. They could afford it. They were a bigger company. They were able to manage it and stay in. But if that had been a small business that we are trying to encourage, this is exactly the kind of thing that, in my humble opinion, that Maryland code ought to be reflecting. If we find other ways of going, of skinning the cat, I know that we're dealing with animal cruelty on a different day, then I'm happy to talk to you about that. But I think that the question that Delegate Atterbury brought up about, who is this really hurting? The big boys are able to handle it, but they're the ones who are going to get the big contracts anyway. It's the small people that are never going to be able to compete, even for the private contracts that Delegate Williams was talking about, because they're just never going to get in the door. So.
Okay, I think that's all the questions from the committee. We do thank you all very much for the presentation on the bill, and that concludes the testimony for House Bill 213. Thank you all very much. Delegate Proctor has been very patiently waiting. And Delegate Proctor is here with us on House Bill 305. Eric Colchamiro, I hope I'm somewhere in the ballpark for that, is also here to testify on this bill. It'll just be the two of them. The delegate will get 3 minutes. Her witness will get 2. And with that, Delegate Proctor, go right ahead. But take yourself off mute and we'll start you over. Please.
Good afternoon, Mr. Chair, Madam Vice Chair, and committee members. House Bill 305, Public Safety. This is a task force on missing persons. This is not the first time you've heard this. It was introduced before. In fact, many of you heard it last year. HB 305 is the most important bill on the agenda when someone you care about is missing. This task force seeks to study best practices for conducting searches. The system overall has made some improvements, but there are many loopholes. When law enforcement is trying to get information that's allowed from hospitals, some hospitals know what they can share, others don't. So that's a loophole. There is a lack of centralization. We should have a tracking system. If we can track packages and we can track election notices, we should be able to track the status of missing person cases. Right now, if you call, it's just being transferred from one person to the other with getting very little, if any, information. And we need a coordinator. We need a state coordinator for the state of Maryland. We have so many cases. I have received a letter from our Prince George's County executive, Angela Also Brooks, who supports this bill. Her letter states that there are over 200 active missing persons cases in Maryland as we speak. Our citizens deserve the use of the best available strategies. When we have searched other states such as Florida and New Jersey, there are two that have done some good work, and we need to take advantage of what they're already doing and what we can put together for our people. As we have talked about before, if you're missing and you're gone more than 6 hours, your chances of being returned safely certainly diminish. So I respectfully request your support, pass this bill out of committee, and hopefully we will be able to get it passed and get some work done. Thank you very much.
All right. Mr. Colchamiro, you are on mute.
Unmuted. Thank you so much, Chair Clippinger, members of the committee. My name is Eric Colchamiro, and I'm the Director of Government Relations for the Alzheimer's Association in Maryland. You have my written testimony before you, but I am here today to issue our strong support for this legislation. The Alzheimer's Association is pleased to support this bill as we work to reduce the incidence and impact of Alzheimer's and other dementia among the over 110,000 Marylanders with this disease. Anyone who has memory problems and is able to walk is at risk of wandering, and 60% of people with dementia will wander. Our advocacy tries to raise awareness of this issue, reducing the risk of wandering and the potential for missing people. And our programmatic initiatives seek to help individuals with Alzheimer's or other dementia and teach them and their caregivers strategies to prevent wandering, including how to best carry out daily activities, the value of a routine to provide structure, identifying the most likely times of day that wandering can occur, to reduce potential anxiety which might lead to wandering. Reassure the person that if they get lost, abandoned, or disoriented, that they have a safe place. And we offer a number of services and resources to support families. We have a 24/7 helpline, and we are always accessible to Marylanders. We urge a favorable report on this legislation.
Okay, we're going to go to delegates. I think Delegate McComas, did you have a question on this one, or was it the last one? It was the last one. Okay. We'll go to Delegate Grammer, who has a question, and then Delegate Williams.
Thank you, Mr. Chair. Hi, Delegate Proctor. Good to talk to you. Is it just missing persons that you're after here, or was the scope of the crimes bigger, or scope of the missing people bigger?
They are identified as missing persons, but they could be folks with autism, as we say, Alzheimer's, or other disabilities. And we do have a list of people. We have our senior citizens, as you know, growing every day.
Okay.
And as we look at that, the numbers start to grow. So it does include the groups I just mentioned.
I just didn't know if you were going for like human trafficking related cases.
At this time, we have been in touch with the state's attorney, Aisha Braveboy, and we will work together, hopefully. But I think that the human trafficking issue is large enough that it will have its own system, if you will.
Okay, I appreciate the questions.
Very quickly, for committee council, Delegate McComas is asking whether, and you are responding right now, Delegate McComas should look in the chat section about you're going to receive notice. There's 3 delegates who are going to go to Ways and Means on a different bill, and that information will be made available to you shortly. Let's go now to Delegate Williams.
Yeah. Hi, Delegate Proctor. One, I just want to thank you so much. I really do agree with the spirit of this bill for a variety of different reasons. My own dad has Alzheimer's, so I definitely understand the concern with, sometimes he tries to act like he's supposed to be able to still drive and tries to grab the keys, and we have to no, you can't do that. So I get it. The only question I really had, I noticed in the list of different entities that would be a participant on this task force, you have MACO, but I was just wondering, let me make sure I have that right in my notes. Oh, no, you have MML, but I was wondering if maybe we should also include someone there from MACO. That was my only thought process in reading the bill. But other than that, I like the legislation and appreciate you bringing this forth.
I think part of the task force's duty will to be determining what other organizations and agencies can be of help and support to us. So this is not a limit. This is just where we're starting.
Okay. All right. Thank you.
Thank you.
All right, I don't think I see any further questions from the committee. So with that concludes, thank you all very much. That concludes the testimony for House Bill 305. Thank you, Delegate Proctor.
Thank you.
All right. Let's go to Delegate, is she back? Yep, she is. Delegate Fisher, Juanita Fisher, House Bill 260. There are a total of 4 people who are going to be testified, including the delegate. 3 in favor, 1 opposed. So we'll go with the 3 in favor first, and that'll be Delegate Fisher, John Giannetti, and Ron Jerichow. So let's go with Delegate Fisher to begin. This is 3 and 2. We did not pass this bill last year. Delegate Fisher for 3 minutes.
Thank you, Mr. Chair. Can you hear me okay?
Yes.
Okay. Thank you so much, Mr. Chair. Thank you, Chair Clippinger. Thank you, Vice Chair Atterbury, and the esteemed members of the Judiciary Committee. My name is Delegate Juanita Fisher, and I'm very happy to present HB 260, which is jury service disqualification. This bill did make it through our committee and the floor last year, but due to COVID and the time, didn't make it all the way, and I hope you will consider it. I am pleased to discuss this issue with you, which basically is about juror enfranchisement. This bill would alter the circumstances in which a person can be disqualified for jury service. Jury service has long been recognized as a civic duty in our country and the ability to take part of the process. After someone has served their time, they should not be disbarred from being in our jury service and being back as a full citizen. Maryland has already led the way in allowing those who have served their time to vote and be back in our voting system. So it's only natural to allow them to be part of our jury service system. In addition to that, 80% of inmates in Maryland are African American, which means our communities of color are most disenfranchised for serving on juries. This would be for civil and criminal cases. This bill will allow equity to be served in our judicial system on all sides and for all Marylanders. So for those reasons and many others to be short, I believe that this committee believes in restorative justice and to restore all civic engagement to all of our Maryland residents. And I ask for a favorable report on HB 260. I have an esteemed panel that will go into further detail and be here to help me answer questions. Thank you, Mr. Chair. Can't hear you, Mr. Chair.
Mr. Giannetti, let's try that again.
Oh, very good. Thank you, Mr. Chairman and members of the committee. It's indeed an honor to be before you. I last served on that, or I started serving on that committee 22 years ago. Back in the day, our non-official motto was, "We might doze, but we never close." I think Judiciary is the hardest working committee in Annapolis. One of the things that's important to know is this bill sits before you in the same exact posture, same exact writing as it was last year. You passed it out of the House, and I was following it on the last days of the session. When it went into the Senate, it actually got a Senate vote in committee, and the committee passed it out. It just never made it onto a calendar. So technically, it made it through both committees, and so I'm encouraged. I think this is one of our major priorities. I'm the lobbyist for the Maryland Criminal Defense Attorneys Association. We're very proud of Delegate Fisher and her stewardship of this bill. One of the things that is clear in Maryland, with only 30% of the African American population, but 80% of our incarcerants are Black. Part of the idea, one of the tenets of racial justice has to be re-enfranchisement, and it has racial overtones, and this is one of the important steps. If you look at the country, we stand right now with 28 other states that say if you're a felon, you can't serve on a jury. 21 states say after you've served your sentence, you can serve on a jury, and it's in a different state by state, but that's a rough breakdown of 28 to 21. So we want, by passing this, we join the 21 states that allow that re-enfranchisement. We think it's very important. The easy way to talk about this bill and how it affects, it's tracked exactly along with the voting, with the vote law. So in Maryland, after you've served your sentence, if you can vote, then you can also serve on a jury. And that makes it easy to understand. People will understand their re-enfranchisement, and it's the right thing. It's the right policy. Again, thank you to Delegate Fisher for her great stewardship of this bill. That's all I have.
Thank you. Thank you, Mr. Jarishow.
Thank you, Mr. Chairman. My name is Ronald Jarishow. I'm a former circuit court judge in Anne Arundel County. I am testifying here on behalf of the Maryland Association for Justice. Under current Maryland law, people who have served or have been sentenced to serve more than 1 year in jail for a misdemeanor or for a felony are prohibited for lifetime from serving on a jury. This bill would change that. Only those people who are convicted of a felony and are either serving a sentence or probation would be prohibited. And that means that a felon who has done his served his debt for society and completed that is no longer disqualified from jury service, which we support. And when it comes to misdemeanors, there are certain misdemeanors that are public punishable by more than 1 year in jail. So for example, assault and battery, that can be sentenced, and the chairman would know these things as well as anybody. Someone who's convicted on a second or third DWI offense can be sentenced for up to 5 years or 10 years. And there is no reasonable rationale to prohibit those misdemeanor violators from serving on a jury. Statistically, as the sponsor recognized, the study I found talked about there being 30% of Black African-American men would be prohibited from juries, according to a study I reviewed in 2003. And the Supreme Court in 1979 recognized that it's important for a criminal defendant to have a jury of the community. the Maryland Court of Appeals addressed the same issue for voter, based upon the voter rolls, about 10 years or so later in a case, and I've cited these things in a report we sent to the sponsor. But the bottom line is that everybody deserves to have a jury drawn from the community in which they live, and not to have excluded people who have either an offense of a misdemeanor for which they maybe got a more than a 1-year sentence, and those felons who serve their debt to society. So Maryland Association for Justice asked for a favorable committee report on this bill.
Thank you very much. We have one question from Delegate Cham. I see Delegate Conaway as well.
Yes, thank you, Mr. Chair, and to our Vice Chair and members of the Judiciary Committee. Bear with me as I wrap my brain around the verbiage of judicial matters. But I did have a question regarding, is there a time, or how long can the person who serves some time in prison, is there a maximum amount of time that this bill is looking at? Is it 1 year? For a person who has been in prison, but they're out, they're working class people like all of us are, that we're looking to allow them the ability to serve as a juror. Is it, could it be a felon who served 20 years, or a misdemeanor, a person who's committed a misdemeanor and served 1 year? Is there a time, amount of time that person served in prison?
I'll let Mr. Giannetti answer that. He looks like he's ready to answer.
Thank you.
Mr. Giannetti, you're muted.
You're muted.
Thank you very much. I apologize. I'm still getting the hand of Zoom. Okay, thank you very much, Delegate, for allowing me to answer. Yes, the answer is it depends on the defendant, and the way that it's written is simple in that regardless of the sentence, once you're finished your incarceration and any other term of your sentence. So sometimes a defendant is sentenced to a year incarceration and 3 years probation. Well, that 3 years is included as part of the sentence. So that person wouldn't be able to vote and wouldn't be able to serve on a jury until that portion of the sentence is completed. So they're finished probation. Sometimes, a portion of the sentence says you have to pay back $10,000. All right. And so that would be a part of your sentence. So once you pay back the $10,000, you served your term, you served your probation, you're no longer under any supervision authority, then you can serve on a jury, same as you can vote.
All right. Are there further questions for this panel? Mr. Giannetti, just to, oh, and that's right. I saw you, Delegate Conway. I didn't miss you. I will come right back. I'm sorry. I have a very quick question on the process. I've gone back and looked again. I don't see where the Senate actually made any or moved this legislation at all last year.
Yeah.
It moved to the House. It got to the Senate, but I don't see any committee votes at all on this.
Yeah, it's funny. We were monitoring it. Of course, we were trying very hard to get it onto the Senate floor. And we had members of the Judicial Proceedings Committee who were present in a voting session who said that it was voted out and it wasn't officially tabulated onto a committee report. So I don't know what the official tabulations were on the very last day, but it did happen on the last day. I'll withdraw from making that representation, but
it's fine.
Okay.
No, I'm not seeking to I'm not making a big deal out of it. I just wanted to clarify for the committee that it's a bill that passed the House, and at least, if a bill passes JPR and there's no record of it, does it make a sound? All right, Delegate Conaway. Delegate Conaway.
Thank you, Mr. Chairman. I believe this question is for Mr. Jarasho. I hope I said that correctly.
You did.
Wondering, do you have any data as to what the different community makeups are? For example, does one community have 20% of people who've been convicted of a certain crime and they've done their sentence, or 40% or 50%? The reason I'm asking this is it seems like if you would use a speeder, let's say a person had a moving violation before and you go in front of a jury that 1% have had a moving violation, they might be very sympathetic to whatever you say. So I was just wondering if you had any data.
I do not, but the study I reviewed from 2003 said that it's 6% of the general population that would be precluded having a felony conviction, whereas it's 30% of the Black community. And that is a terrible racial imbalance, which this bill would certainly go to balance those things out by making it equal for everybody to have who served their sentence, served their probation, would be no longer disqualified. But it's very hard to track, who's got misdemeanor violations. Maybe parole and probation would have something like that. But I did not review any study that broke it down the way you're asking.
So you're saying that 6% of non-African Americans have these felony convictions that they've taken care of, and 30% of African Americans have that conviction, right?
I think that the way the study reported it, 6% of all persons, that probably includes all ethnicities as well, but in the breakdown of African Americans, it was 30% of Black men that would be excluded from the jury, according to the
And what's the ratio of Black men compared to others in the state of Maryland, or what this study took?
They did not break it down in that way, I regret to say.
Okay, thank you very much.
You're welcome.
Are there further questions for the panel?
Chairman Clippinger, can I add one statement to the answer to the question of the last questioner? Very quickly, about 75% of the defendants in Maryland courts are African-American males. All right, so if 30% of the African-American males are disqualified, you would say that it might be harder to reach a jury of one's peers if those people are not qualified to even be serving on those juries.
Yes, I understand that. I thank you very much. What I was trying to get an understanding of is what was the total pool, what's the total number of people that were in this pool, and how many of them were African Americans, so I could see the disparity between the 30% and the 6%. But I understand you. Thank you very much.
Thank you. Seeing no further questions for this panel, that's fine. We will go from the supporters of the legislation to those testifying in opposition. That would be Steve Kroll.
Good afternoon, Mr. Chairman, members of the committee. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, the Executive Director of the Maryland State's Attorneys Association. And I've been prosecuting cases, I don't give a number anymore, I'll just say since 1984. Yes, that long. So we are in opposition and ask for unfavorable report as to House Bill 260. And so I want to just indicate what Rich Gibson, who's the State's Attorney for Howard County, said, and I quote him from his written, which you don't have, but I do have here. We would be inclined to support a bill that considers the passage of time, length of incarceration, and type of criminal conduct for a potential juror in modifying who was disqualified for jury services. We are in favor of a pass to have people come back to jury service. Being said, we had a vote in our committee, in our board, and unanimously, we're talking about all the state's attorneys, not some, but all voted against this bill. And that's a rarity to get all voting against. And in doing so, we look at the bill itself. Number one, it says probation only. So you can be on parole and be eligible. And that doesn't make much sense at all. So not include parole. The second, if we look at the language of the bill, it says on line 1 on page 2 of the bill, an individual is not qualified for jury service if the individual, and it goes down to then number 4, has been convicted in federal or state court, and there's a bracket there, and it goes down to number 5. That means that's not included in 4 and the first part of 5, meaning any charge pending is needed. So if you are someone with a felony, with a misdemeanor that was pending, you couldn't sit, and that was the law. Now you can. So you're pending a case and could be sitting on a jury at that time. If that display bias when you're pending a case, that's not fair to the state. It's not fair to anyone. So that's not being included also. So if you look at the language, this bill is fraught by being written in this prosecutor's opinion. It needs to be written better, in other words. And we are willing to work with the sponsor for a path to get people back to voting, but not this bill. Unanimously rejected by all state's attorneys, and that is a rarity. People who are biased, we can't tell who is biased and who is not biased. But what we can say is, if you have a pending charge, you most likely will be biased. And I would strongly suggest to the proposal to argue differently. If you're pending a case, you will be biased. We will and include and would like to see a path to have people come back, but not this bill. And we ask for an unfavorable report.
Okay, thank you very much. We have question from Delegate Moon. Delegate Moon?
Thank you, Mr. Chair. I'm not a trial attorney, but could you just illuminate this point you're trying to make here? Don't you have strikes for cause whereby a potential juror who's might be biased and, by exactly the facts you suggest could be struck anyway?
That's true, but if you have a pending case, we get to use all our strikes for those who are pending who we believe are biased. So take more strikes, and that seems to be fair, doesn't it, Delegate Boone?
Okay. Delegate John Carden.
Thank you, Mr. Chair, and thank you, Mr. State's Attorney Kroll. It's always good to see you.
I'll just interrupt the Delegate Carden. I'm not State's Attorney yet, only special
Assistant State's Attorney Kroll. Assistant State's Attorney Kroll. So every time that I've watched voir dire and watched questioning of jurors, of prospective jurors, every single time, whenever the judge asks a question, somebody raises their hand. The judge then says, if the person's not automatically disqualified, the person says, is the fact that your father is an ex-felon or that your mother was hurt by somebody, is the fact of that, is that going to somehow interfere with your ability to be impartial in your decision? So if you ask the person the question, you're going to have a lot of people who might have been convicted, may have served time, but they can still be impartial. Why should they automatically be struck if the judge is asking everybody about whether he's asking somebody whether if they eat Swiss cheese sandwiches, whether that's going to make them impartial? I mean, judges will ask somebody anything and everything. Why wouldn't this just be part of that conversation?
Well, if you were facing a possession with intent to distribute and your jury panel was someone also facing it, it's hard to believe that you can be fair and impartial. And I find it hard to believe that someone can say they have after my 36 years of doing this. If you're in a DV case and you're pending a DV case, that you can't be fair and impartial.
Does the judge have the judge have the right to decide that somebody can't be impartial and exclude?
Judge certainly has the right to do that. Certainly. But if you've done trial work, you see, and Mr. Jarashel knows and Mr. Giannetti knows that sometimes jurors will not answer the question properly for whatever reason. But what my experience tells me, and I'm sure their experience tells me, if you're facing a crime, having been already charged with or convicted of that crime, you're most likely not to be fair and impartial.
Thanks.
All right. Are there further questions for this? Or I'm sorry, Delegate Fisher. Delegate.
Thank you, Mr. Chair. Hi, Mr. Kroll. Good to see you again, as always. I just wanted to make a clarifying point because I actually did meet with two state's attorneys this last week that were in favor of this legislation. So I'm not exactly sure how the State's Attorneys Association does your voting, but I definitely know at least two state's attorneys that I met with personally about this bill were in favor of it. And I actually, told them, don't worry about putting testimony in favor. We have a lot going on. So I just want to clarify that to the committee and on the record that I don't think that statement is accurate.
Well, I was at the meeting. I know they contacted you, but they didn't tell me what they told you. But I can tell you at our meeting, it was a unanimous vote. I know they contacted you afterwards because one of the state attorneys told me, but at our vote, that's how they voted. It was unanimous.
You can always invite me next time you vote. I would love to come.
Well, maybe one day you'll be state's attorney too, and I'd welcome you to the meetings also, Delegate Fisher. Maybe.
Okay. All right. Are there further questions for this panel? Delegate McComas, who indicated she had a question for one of the proponents, but go ahead.
Well, I think it could be, if either one could answer, because everyone has a right to be judged by a jury of their peers, and because of the discrepancy of the percentages of folks that are in the community versus folks that are are, in the prison system. I was wondering, is there any constitutional issues, or has this ever been brought up by the courts? So Mr. Kroll or Mr. Giannetti, or both of you, if you could kind of weigh in on that, I'd appreciate it.
I'll answer first. The Supreme Court said that you're actually entitled to a jury, a criminal defendant is entitled to a jury of the community, as opposed to the phraseology of a jury of your peers. And that was in 1979. And then the Court of Appeals of Maryland addressed a similar issue where a jury in Talbot County was challenged because it was composed of people selected from the voter records. And there was a challenge that said, this was in 1997, the court said, no, the voter records are open to everybody, and so there's no bias involved in that. But for the same phraseology, you're entitled to a jury of the community. So when you talk about people who are in prison being excluded, I think that you're talking about the community coming from the county in which the person is being tried, and that community would not include anybody who's in prison at the time. That would seem to be my interpretation of it.
Okay. Seeing no further questions, that's going to conclude the testimony on House Bill 260. Thank you all very much. We're going to go to our final bill of the day. That is House Bill 227. Delegate Charles, who is with us. And we are have a few fewer people here, I think. That's in large measure because we've had some people who have had to stand in other committees, but I do believe we still have a quorum. So we're still going to keep going. And so this is 3 and 2. I see the state's attorney from Prince George's County. So what we'll do is 1, 2, 3, 4. Total of 4, including Delegate Charles. So this is 3 minutes for Delegate Charles, 2 minutes for everybody else. And I will let you go ahead, Delegate Charles.
Thank you, Chair Clevenger. I had a video that I was going to share.
I remember that now. Go right ahead. We might need you to share your audio somehow. Not sure how this works. See if Dylan can figure it out.
I am screen sharing it from my end, and my audio is all the way up. Let me see.
Okay.
I'll restart it.
Uh-oh.
Are you hearing it?
No.
All right, I'm not sure what the issue is on my end. Let me stop sharing it. All right, I turned on our speakers. Are you hearing it?
No.
All right, okay. I apologize. It's not working. I can share the link with everybody in the chat room.
Yep. Thank you, Dylan. I truly appreciate you.
Sorry about that.
It's okay. It's okay. Yeah, we will definitely share the video with everyone. But Chairman Clippinger, Vice Chair Atterbury, and the honorable members of the Judiciary Committee, I'm pleased and grateful for the opportunity to be here to bring forth House Bill 227. As you all could agree, this has been a very tumultuous year for our country. But with the video link that I sent you all, what it would show you is the light that was shined on the issues that the African-American community has been facing for years. And with that being said, I was asking for a favorable report on House Bill 227. And what this bill does is it authorizes citizens to pursue civil lawsuits up to $10,000 against those who misuse 911 to summon a police officer for improper reasons. In my opinion, and others, this bill, if passed, would discourage the discriminatory and unsafe summonings of these police officers. Because as we all know, tensions between civilians and the police departments are at an all-time high, especially right now in 2021. And allowing people to continually summon police officers for ordinary activities, it creates an unsafe environment, not only for the ones who the police were called on, but for the police themselves. Additionally, this wasted action siphons off resources from our own police departments who could be actually out there doing work that's truly needed. I have a panel of folks that are here to discuss with me as well. There were a ton of letters of support. We have letters from the Women of Color for Equal Justice, which you should have received. We have the NAACP of Maryland, who have provided testimony as well. On call, we have the Prince George's County State's Attorney. We also have a deputy sheriff from Prince George's County Sheriff's Department, who provided testimony as well. And we also received testimony from CASA in Action. I would now like to give my esteemed panel the ability to come on and testify in support of House Bill 227.
So let's do this. Let's go ahead with the state's attorney for Prince George's County, Ms. Braveboy, and then we'll go to the other person. Oh yes, okay, and then we'll go down the list to Hazaifa Mohammed. All right, so Ms. Braveboy, are you there?
Yes, I am, and thank you so much, Mr. Chair, Madam Vice Chair, and members of the committee. I am here to testify in strong support of House Bill 227. You know, Delegate Charles is my delegate. And when I think about why he thought this bill was so necessary, I couldn't help but think that he could be a victim of someone who misused police resources. No one is immune, no matter what your lot in life is. No one is immune to certain racist actions, certain discriminatory practices by our fellow citizens and residents. And so it is really important for us to protect, in particular, our Black men, our brown men, and other people of color, as well as everyone, from unnecessary contact with police. You know, we have seen instances where people were had the police called on them for jogging while Black. We've had instances where people had police called on them for bird watching while Black. We've had instances most recently where people wanted to use law enforcement resources for someone who simply had an iPhone while Black. And this is just a small sample of the types of cases that we've seen all across this nation. And so we think it's very important to discourage this type of behavior. We did share with the bill sponsor that we are just asking for one amendment to clarify that this bill would not apply to domestic violence survivors. We're very concerned that it could potentially be used because of the broad language in Section A4. It could potentially be used by domestic abusers to intimidate victims. So we're just asking that that is clarified in the bill. But we absolutely believe this is an important bill. We know that Oregon passed a similar law recently, and it is our understanding that it has had a positive effect on the number of people who are improperly, have the police improperly called on them. And this civil liability, we think, would be a big and important deterrent. So I want to thank my delegate for sponsoring this bill and thank all of those who are testifying in support of it. And I ask the committee for a favorable report on House Bill 227.
Thank you very much. Zaifa Mohammed.
Thank you, Mr. Chairman and House Judiciary Committee members, Madam Vice Chairman. On behalf of the Council on American Islamic Relations, I want to thank you for this opportunity to testify in support of House Bill 227, improperly summoning a police officer. The Council on American Islamic Relations is America's largest Muslim civil rights and advocacy organization. Its mission is to enhance the understanding of Islam, protect civil rights, promote justice, and empower American Muslims. Over the course of especially the last year, there have been many issues on the forefront of our society, and among them is increasingly excessive police interference with daily life. Police are called too often on people of color for non-emergency situations, which can escalate quite rapidly. Maryland's Muslim communities are comprised of very diverse ethnic and racial groups, and many individuals have also had their race or religion weaponized by others who seek to do them harm. These unnecessary 911 calls are not only waste government resources and divert police officers' attention from legitimately urgent disputes and crimes that warrant their intervention, but they also increase the risk of a hostile situation which can endanger innocent lives. We support this bill because it sets the tone for accountability, and we believe it will help discourage this behavior in the future. Therefore, we respectfully urge your vote in favor of it. Thank you for your consideration.
Okay, are there any questions for the proponents of the bill? I see Delegate Grammer, then Delegate Griffith, and Delegate Anderson. So we'll start with Delegate Grammer.
Thank you, Mr. Chair. Thanks for bringing the bill today, Delegate. So as I'm reading this here, I handle a lot of scenarios that I really can't do anything about in my district. It seems to be a lot of neighbor relationship issues. Some of it's borderline illegal. I'm reading through the bill here. I think this is a really interesting idea. But do you think some of this might be loose enough so that anytime police are called, one of the clauses of this statute could be evoked? I mean, in a general neighborly dispute.
I don't think that it could be invoked, but under the current Maryland Criminal Code 9501, to make false statements to a law enforcement officer with the intent to deceive and to cause investigation is for a fine of $500. So if someone was to use that already and make a improper call for an issue like this that you're talking about, there are provisions in place. What this is to allow for a civil claim to be brought for $10,000 in monetary damages for those who have been had the police used against them in a negative manner.
Gotcha. Does this apply to, like, I want to use the term swatting, like if someone is, this doesn't mention like physical harm, but if your intent was to call the police to create a volatile situation, do you know if there's a different part of the statute that applies to that, or would this apply to that, or is that something we've missed?
I'm not sure. I'm not sure, Delegate Kramer, but I am willing to put any provisions into the bill to tighten it up. I'm willing to work with all members of the Judiciary Committee and the subcommittee to make sure that we tighten this bill up, to make sure that it is the best way to protect those who had issues brought against them.
I appreciate the questions.
All right, we're going to go to Delegate Griffith, then Anderson, then Williams. Delegate Griffith.
All right, thank you, Mr. Chairman, and thank you for bringing this bill forward. My concerns are always trying to unpack the unintended consequences and how a piece of legislation could be misused. So I guess my question is, with the current COVID restrictions, if, and this is something that's happened locally in my jurisdiction, if a restaurant has been accused by a patron or somebody walking by of not following COVID restrictions, mask violations, social distance violations, and someone calls the police at a restaurant, even though that's the purview of the health department, to draw attention to that restaurant in a matter that's very difficult to prove just on one witness providing the information, and they repeatedly do that, or even do it one time without being able to substantiate it, just to try to bring harm to that restaurant for whatever reason, whatever the motivation is, would they be protected under this bill?
I want to make sure I understand your question, Delegate Griffith. So are you asking that if an individual comes into a restaurant with a mask off and the police was called on them?
No, I'm saying, say an individual witnesses inside a restaurant or any business, individuals in that business, or just reports that those individuals are not following COVID guidelines, and they're calling law enforcement to report that, repeatedly draw attention to that business, even potentially harass them. Would this also apply to businesses and entities in addition to individuals?
I don't think this matches up to what is actually going on to what you're saying.
Ooh, we lost your sound.
Delegate Charles, we can't. Try again.
I'm sorry, am I unmuted?
That's better now.
Okay, thank you. Yeah, I don't think that this qualifies for what you're stating, Delegate Griffith, only because the governor has mandated the COVID restrictions that the state should be following, that restaurants within the state should be following. And if someone calls the police or anyone because of violations, they are in fact violating those provisions set in place by the governor. So I don't think this falls in line with what you're saying.
But I may be asking the question wrong. Please bear with me, because I'm trying to formulate my question as I'm asking it. But in the sense where this individual witnesses it or may not, because it's difficult to prove this person witnessed this violation, right? But they're still calling law enforcement to respond to this violation, or repeatedly call. If it was established that this person is just trying to harass a business for whatever reason, would a business, and take any example, would a business also be protected under this law?
In short, Delegate Griffith, what this boils down to is the burden of proof. And the burden of proof is by preponderance of the evidence that'll be provided. So in short, they would have to, a lot of times, if you were able to see the video clips that I provided, it's people that actually had video of folks having the police called on them. It was folks recording the interactions of what led up to the police being called. So this will fall into a burden of proof.
Okay. All right, thank you very much, I appreciate it.
Delegate Anderson, then Delegate Williams.
Yes, thanks, Mr. Chairman. I got a question of the state's attorney for Prince George's County. Madam State's Attorney, you still with us?
She is not. I don't see her anymore. No, she is not with us.
Okay, then maybe I'll ask Delegate Charles. In your opening statements, you indicated that one of the reasons why you wanted this bill to be that a lot of times it will cut down on wasted time by police officers on call not necessary, right?
Yes, sir.
Okay. And my question is, I don't know how many calls officers in Prince George's County get per day, but on a normal day, a police officer in Baltimore City can probably be called 12 to 20 times, different locations. And many of these calls are prompted by private citizens who saw something wrong, or something they thought was wrong, and probably could result in a person being offended, and therefore having the ability to use the tools in your bill to take an action against that person who made the call, right?
I'm hoping that's not the case, Delegate Anderson. You know, the U.S. Department of Justice, the Office of Community Oriented Policing Services, they did a study. They started studies back around 2002, and they issued out reports called the Misuse and Abuse of 911. And they did that in collaboration with the National Emergency Number Association. And what they found, it's kind of hard to track the exaggerated 911 calls, but they happen. They happen frequently. But they don't have actual data to prove otherwise how frequent it is. So when you talk about the amount of calls that come into Baltimore City and what comes into Prince George's County, which are two areas in our state that have a high population of African Americans, I think this bill, the way it comes in, and like I said before, I'm willing to work with, fixing any gaps in the bill that will make sure we're protecting people at all costs. But I think what this does is it puts us in a position to hold those accountable who do exaggerate those calls. Granted, somebody may commit a crime and they see them outside committing that crime and they call the police. If there's not enough evidence, there's not a preponderance in evidence to submit to bring such a lawsuit. But I think we still need to have these level of protections in place to make sure that when folks have the police called on them, they have a level of recourse, especially when the police are called in an exaggerated manner.
Okay, you make reference to having a preponderance of evidence to bring the suit, but you don't actually need a preponderance of evidence to bring the suit. All you have to do is make an allegation in civil court that this person did X, Y, or Z. I guess the preponderance of evidence comes in whether or not the person gets convicted of the crime. But any person who feels wrongly or who feels wronged by a police call from their neighbor for something they may have been doing innocently can avail themselves of this this new tool to bring a suit against an individual who may or may not have been doing this in a malicious fashion. And there is no burden of persuasion needed to bring the suit. You just have to say, I think this happened.
Well, one of the things that, you didn't discuss in your statement, Delegate Anderson, was because you didn't get a chance to see the video that I provided for testimony. But a lot of these cases, there was evidence of folks recording the situation taking place, and they had no level of recourse to bring any type of suit against these people for making these calls to the police against them. We may not have all the evidence every single time, but if you have that video to be able to show that somebody called 911 on you for jogging in a community, somebody, your neighbor, called 911 on you for being outside, your daughter outside selling water, your neighbor called 911 on you because they didn't like the way your car was parked in the driveway, unless you're not violating any rules, if that's constantly happening over and over again by that neighbor, and it's considered harassment at some point in time, like I said before, Delegate Anderson, I'm willing to work with the Judiciary Committee to narrow down and tighten up any gaps that may be in this bill. If you guys believe there are gaps, I am truly willing to work with you all, but I think we need to have some level of recourse in place for the Marylanders in the state.
Could I have one follow-up question, Mr. Chairman?
Go ahead.
Thank you. All right, let's say the bill goes into effect, and do you think that the police officers who were summoned under this scenario would have to show up in court as well?
Yes, sir.
Okay, so we're taking them off the street for an undisclosed or unpredictable amount of time to deal with something that they had nothing to do with.
Well, the police will have to give a report. In my opinion, don't you think, Delegate Anderson?
No, I'm saying is that
if there was an issue, if they showed up to a call and they found that this call was unfounded for any particular reason, their evidence would be the most important piece of the conversation.
No, that's not my point. My point is that they show up They find the call unfounded and they go back to their duties. At some point, a month from now, they're summoned to court at 9 a.m. in a civil matter between the person who made the call and the person who was offended by the call. They'll have to sit in court until their case is resolved, whether it's resolved that day or the next day or whatever. Do you think this would take an inordinate amount of officers off the street to respond to these allegations when they really, all they were doing was their job?
I don't know if it'll take them off the street for the amount of time that you say. They're being called to 911 calls for the same exact issue. They're being taken away from being able to police other communities or make sure they're keeping our streets safe. But instead, they're being called to fictitious 911 calls. So it could be said one way or the other, in my opinion.
Okay, thank you very much.
Thank you. We'll go
Thank you,
to
Delegate Anderson.
Delegate Williams and then Delegate Arakan. Delegate Williams, please.
Yes, I have a question and I apologize. I was in another committee, came back, so this might have been addressed because I did hear the state's attorney talking something about domestic violence when I came back in. So maybe this was already addressed and I apologize. I was looking at the letter from the House of Roof and with regards to their amendments that they would like to see. And I wasn't certain if you had addressed those yet before the committee or not.
Yeah, so this same bill was introduced last year. And we addressed the House of Roof amendments. We put those in to make sure that we were definitely having protections in place for folks who were abused or through domestic violence. And I just have to make sure that we have those same amendments because I asked bill drafting to put the bill in as amended from last year. So that amendment should still be in there.
Okay, all right, thank you.
Okay, I'm going to Delegates Arakan, McComas, and Grammer, who are next. So Delegate Arakan, please.
Thank you very much, Mr. Chair, and thank you, Delegate Charles, for being here. I totally get what the goal is of this bill. I'm a little bit worried, though, on page 2, line 3, number 3, it's and number 4, it says feel harassed. So we're not really looking for intent here. The way the bill's drafted, it's really just looking at, I mean, feeling is so subjective. You know what I mean? Like, I moved to a new area a couple years back, and my neighbors kept calling animal control on me because I had a livestock dog that lived outside full time. Even though every time they came, they said, "You're not breaking the law." Like, repeatedly, people would call on me. I felt harassed, but like, probably my neighbor just thinks that I'm a mean person for having a dog that lives outside, even though the breed is intended to live outside. Do you know what I mean? So now we're in a situation where she didn't really have the intent of harassing me. She was really just worried about my dog, but I was feeling harassed and we moved. I didn't even like living there. So who's guilty here? Do you know what I mean? So I'm worried that the language doesn't account for the intent of the person who's being sued in this situation. That's my first concern. Do you have any ideas? Would you be willing to remove that line?
Like I said before, Delegate Arakan, I'm willing to work with the Judiciary Committee, with the subcommittee to make any adjustments. Okay, I see counsel I'm sorry.
Yeah, I see that. Yeah, I see that too. Yeah.
Yeah, so we had to put that amendment in as well. So I'm willing to put amendments in that everybody is comfortable with. I just want to make sure we get something on the books that can protect folks from these issues. But I'm willing to work with the committee to square the bill up.
Okay, the other question I had was, I'm a little bit worried that it might have a sort of a chilling effect on people reporting crime, or they would just switch to reporting things anonymously. Like they just wouldn't give their name, or they would call from a payphone, or they would call from somebody else's phone, just not give their name. And then, you know, if as soon as this bill gets out, people know that this is the rule and they don't want to get sued, wouldn't they just stop using their name?
I think people will still, if a crime is taking place, I think people will still call 911 for a crime. It's just because you're walking inside of a hotel, I don't think you belong here, somebody calling the police on you, or you are sitting down inside of a Starbucks and you're waiting on some folks for a meeting and the police are called on you. Right. It's that level.
Yeah, I mean, that's disgusting. I hate it too. I'm just, if we could tailor this language so that we can make sure that we're capturing those wretched people and we're not capturing sort of everybody that wants to call and report a crime. Because I'm just thinking if I was a criminal, I would probably then try and sue everyone that ever called on me just because why not? You know what I mean? There's a lot of frivolous lawsuits out there lately. So, all right. Thank you very much.
Thank you, Delegate Erica.
Delegate McComas.
Thank you, Mr. Chair. Just briefly, Delegate Charles, what would you think about instead of immediately going and suing somebody, to have some kind of mediation, particularly if it's neighbors within the neighborhood? It just seems like litigation is not a good way for neighbors to deal with one another. Like if there's parking issues or noise or things like that. It's community, and anytime you sue somebody, that really harms community. So what are your thoughts about that? In other words, have a mechanism that you go to court as the final solution, but things are mediated, because the courts are really, very, very busy. And with this COVID, I mean, it's putting everything back. So what are your thoughts?
When you mentioned that about neighbors, the first thing it made me think about is when certain minorities move into communities and they're the first Black or the first Asian or the first Hispanic in certain communities, and you have a neighbor who doesn't want that particular person within the community, and they're constantly calling the police on them for frivolous or for lies, frivolous actions or for lies. I don't know how much how sitting in front of a mediator fixes that. I think what will stop that person from constantly calling 911 is the financial impact. That's just my opinion. I think that alone would stop them. And maybe they're rich and maybe they don't mind spending $10,000 every single time they're found guilty of making racially motivated 911 calls. That's my thought, Delegate McComas.
Thanks, sir.
Delegate Grammer.
Thank you, Mr. Chair. Second bite at the apple. When Delegate Griffith asked some questions about the health issues, it really made me rethink the way I was asking my own question. So this could be much bigger than just a racial issue. Let's say someone came, let's say you and I had a business, we made sandwiches. The neighbor came over and he said, I hate you guys. I'm gonna do everything I can to get at you. We got him on tape. And then he calls the health department constantly, and he's got the health department and the police in our business. We could use that evidence to say, look, there's no real issue here. This guy is just trying to humiliate us, bring grief to our life. He's trying to damage us. Is that generally what you're getting at? I'm just saying it is much bigger than a potential racial issue, and that is very valid. But this also applies to any context which a person could use police against you.
In those words, Delegate Grammer, I think you hit a couple of pieces, and it definitely could, and that's part of the discussion that I'm willing to have with the committee as far as making amendments to tighten it up, so that it's not so widespread, and that we can actually limit but protect folks who are having 911 called on them for frivolous reasons.
Yeah, and that's what I want to kind of glean from you. Frankly, I don't think it should be limited. I think it needs to be changed in a couple of ways, but I like it generally if I can prove that if someone is purposefully using police to damage me, to humiliate me, to bring grief to my life, and I can prove that, I like the idea of having standing to make that a civil issue. So I'm not sure if that was your intent, but maybe we could talk a little bit more. And I think it does address some of the issues you've brought to us, but I think it addresses some bigger issues, which in my time in office, I don't see that people have a way to, they don't have any standing. They don't have a way to deal with those. And I think this could be helpful, but maybe let's connect down the road a little bit. Again, I appreciate the questions.
Thank you, Delegate.
Delegate Shetty.
Thank you, Mr. Chairman. Thank you, Delegate Charles, for bringing this really important piece of legislation to us. I think it's really timely. I just have, I guess, one question, but it may potentially lead to a second question. So my question is related to the language that you have in your bill. Just curious what you have in mind on Section A1 on infringing on a person's rights under the Maryland Constitution or the U.S. Constitution. What did you have in mind when including that language?
Stand by. I could barely hear you, Delegate Shetty.
Oh, I'm so sorry. I think my microphone is a little faulty. Can you hear me better now?
Yeah, I can hear you.
Okay, so Section A1, infringing on a person's rights under the Maryland Constitution or the U.S. Constitution. Just curious what you had in mind when you included that section. Can you give an example?
Yeah, you're walking down the street and somebody doesn't believe you should be in this particular neighborhood. It looks like this guy is here going to rob a place. You're just walking down the street, leaving a friend's house. And so they're violating your constitutional rights. You're not doing anything. You didn't break any laws whatsoever. You're just walking down the street in a neighborhood, which you have every right to be in. And for somebody to call the police on you, or you're sitting inside the Starbucks and you're waiting on somebody and they call the police on you, if there was nothing those gentlemen in the Starbucks were doing that deserved the police to be called on them.
Right.
There was
and I
no
think
reason.
Awesome. Those are really great examples of why this type of legislation is very timely. But I think later in your bill, you have specific mention of causing a person to be expelled from a place in which the person is lawfully located. And I think that the examples you provide there are probably maybe more relevant to that section. But just curious if, like, for example, the constitutional language could be interpreted as including like Second Amendment rights or something else, like maybe that's more broad than what you had in mind, which is like forcefully expelling somebody from a place that they had every business to be. So I'm just kind of curious if like there was a specific other reason that you feel strongly that the constitutional language should be in there, or if perhaps it may unintentionally be broadly or broadening the language beyond what you intend.
No, there was nothing that was specific to it, but just making sure that we had protections under the Constitution of the United States and under Maryland. But like I told every other delegate, I really want to work with the committee to come to a level of agreement on what works best and how we can still make sure we put these protections in place for those who have the police called on them in this manner.
No, and I commend you for your willingness to look through how to tighten the language. Like I said, I believe that this bill, as well as other bills that we're looking at and how to address this specific type of police engagement, is really important that we look at this session. So I'm very grateful to you for bringing it to us. Thank you, Mr. Chairman, and thank you, Delegate Charles.
Thank you, Delegate.
I have one final question, then I think we're going to wrap this up. Delegate Charles, is there anything in the bill that indicates that the statement that is made to the police officer has to be false?
Inside the bill now, it should be the language in there if they're making a racially charge. Let me go open the bill up because I do not have the bill open in front of me, Mr. Chair.
That's fine. While you're doing that, we heard a bill from Delegate Jackson yesterday with regard to a false statement. And his idea was to make it a hate crime under the hate crime statute and keep it under the, or bring effectively an enhanced criminal charge. I'm sorry that the state's attorney has left because I would have been interested to hear her thoughts about whether this should be a hate crime on the criminal side as opposed to a civil action. But let me know when you have the bill. I will tell you, Delegate, I don't see where the statement that is made to the police officer that would give rise to potential embarrassment or humiliation or harassment has to be false.
Outside of a person may bring a civil action for damages against another person who knowingly causes a police officer to arrive to a location to contact the person with the intent. That's where the language, but Mr. Chair.
I understand. You're willing to work with the committee, and I've got that. I guess.
All that.
Got it.
So I will repeat that.
Welcome to Judiciary again, Delegate Charles. It's all right.
Hey, listen, I got a chance to sit in there with you guys a couple times last year, so I'm willing. I'm definitely willing to come back and sit with you and Delegate Atterbury and whoever else. So you just let me know.
That's fine. Sometimes we enjoy these bills a little too much, and I think we have now. So we're going to stop, and we're going to let you off the hook here a little bit, but we're happy to we're happy to talk with you more about this.
I appreciate you.
I don't see any questions. Even if I do see any more questions, I don't think I see any more questions. We're going to give Delegate Charles, honestly, thank you very much for bringing the bill. The language or the link that he created a video for his testimony, that is in the chat, and I encourage people on the committee to look at that.
And I'm sorry, Mr. Chair, I didn't mean to.
It's in the chat. You can go.
No, but I didn't. It's not in my chat because I was out and then I came back in. And
all right, we'll send that around. If Dylan could resend that out really quickly before we go off the air, that would be fine. But with that would include the testimony on House Bill 227. Dylan is going to hold for the link a little bit longer, and we'll get it out to everybody. Committee, that's the end of our bill hearings for today. I would anticipate that tomorrow is going to be a little bit longer. We have a long list of witnesses, particularly on Delegate Jazz Lewis's legislation. It's a significant list of witnesses that actually might be hitting the maximum number. So we will have to keep that in mind. We'll also be dealing with legislation related to sexting tomorrow. So there it is. Okay, the link is in the chat. If you want it, you need to grab it. And we'll thank you all very much. And thank you all for your time here in front of the committee. Have a good day.